would I also be correct if I apply that statement in respect of the National Petroleum Corporation?
No, you wouldn't be correct if you apply it to that entity.
All right. Is that because that NAMCOR Trading and Distribution was then created for that specific purpose?
That's correct, Your Worship.
Okay. During the period 1 December 2022 until 31 May 2023, you have that period?
Yes.
Can you just repeat the period?
As it pleases you, Your Worship. During the period from 1 December 2022 until 31 May 2023, what position, if any, did you occupy?
I was 23.
Okay. And during the same period, being 1 December 2022 until 31 May 2023, what position, if any, did Mrs. Jennifer Hamukwaya occupy?
I'm speaking under correction because her contract had expired at some point. So I'm not so, I'm not so sure. Cannot remember.
Okay. Furthermore, during the period 1 December 2022 until 31 May 2023, what position the Willemse when you are still employed at the National Petroleum Corporation? What was his position, if you recall?
Yeah, he was the executive responsible for supply and logistics at NAMCOR.
Okay. Was he the executive or was he the acting executive? What was his substantive role?
I think he was the acting executive, as far as I remember, of NAMCOR Trading and Distribution.
Hamukwaya, can you refer to them as Hamukwaya? Can you refer to them as accused number 2 and accused number 3?
I will do so, Your Worship, as it pleases you. Okay. Thank you. Generally, in that setup of yours, who would be responsible for the final decision to approve a fuel reseller or a petroleum products reseller?
I mean, all final approvals and signatures are done by the managing director.
Correct. All right. And then that culminates in the entering of an agreement, isn't it, between NAMCOR and the resellers?
That's correct, Your Worship.
And those agreements we would call fuel supply agreements, isn't it?
That's correct, Your Worship.
And those fuel supply agreements, the signatory to those agreements in respect of your employer would be yourself.
That's correct.
Okay. Of that nature, it paginated page 185 of the bundle of documents. One such agreement you will find at 185. Once you are there, you can just inform me.
I'm there, Your Worship.
Okay. All right, so that is typically the kind of agreement you would enter into with the fuel resellers or petroleum products resellers.
That's correct, Your Worship.
Okay. And in terms of that agreement, there would be, it regulates then that relationship.
That's correct.
I want to propose to you that those agreements with the fuel resellers also contain dispute resolution clauses.
That's correct, Your Worship.
With me when I put the following statement to you, what would you say? And that statement is, if you look at the credit policy of NAMCOR, it excludes the institution of criminal proceedings against debtors of arising from it. What's the range? Because I want us to understand that this is not it. What's the range? Because I want us to understand that this is not a unique agreement that was entered to with these entities. Give us a range in your tenure.
I must have signed at least a dozen or dozen and a half of this type of agreements.
All right. Then I want you to please. Okay.
Exhibit
States that following the transfer of ownership of the assets from NAMCOR Trading in that agreement at the same time authorized Enercon to utilize and store their petroleum products that are procured from NAMCOR in those assets.
That is correct.
So it's a purchase from Enercon, and then at the same time you said once transfer is taken, Enercon now has the right and authority from the new owner. And then the next question would be, accused person number 9, my client, Mr. Leo Nandago. How do you know him?
I do not know him. I met him for the first time here at the court.
Okay. You meet him here for the first time. Are you aware that he is charged with making a... Okay. However, you meet him only here for the first time.
That's correct.
Okay. The previous question I asked you around who would typically be representing Erongo Petroleum CC, we agreed would be Mr. Oste to Mr. Mulunga. As it pleases the court.
Advocate Mulunga.
Thank you, Your Worship. Now, Mr. Mulunga, just to start.
In villages.
And your relationship, apart from NAMCOR having purchased the assets from Enercon, your personal relationship with the first and the second applicant is actually good.
Well, yeah, it's not bad, but I mean, I actually never really had a personal relationship with them.
You can proceed.
And it receives funding from government as well, the National Petroleum Corporation of Namibia.
That's correct.
And the National Petroleum Corporation, or NAMCOR, also has 2 subsidiaries, as you mentioned.
That is correct, Your Worship.
One of them is NAMCOR. Are you saying NAMCOR Trading and Distribution had a different budget from the one of the parent company?
That's correct.
So I put it to you that that proposition you are trying to put to court is absolutely not true. That NAMCOR Trading and Distribution is a different
Director of both companies, and I was the managing director of both companies.
So how then plausible is your explanation to say you were managing this and the parent company, but yet you are saying it's a different entity altogether from the parent company? NAMCOR Trading and the parent company. NAMCOR Trading and Distribution, you are saying, yeah.
Petroleum Corporation, a creature of the the statute, there are two different entities. You can have two schools being headed by one principal. It doesn't make them one school. I think it's unfair to carry on with this question because this will be apparent during the closing submission.
Funding from government. In fact, that is our position from the statutes also. It's a state-owned enterprise which does not have a separate legal entity from the parent company. So what is being said is lies. That is not according to the law or the correct position in the law.
Yes, the
legal identity. They are one and the same.
I disagree with it, Your Worship.
All right. Now, let me ask you this. NAMCOR Trading and Distribution, does it have its own office separate from the one at Aviation Road?
It's housed at One Aviation Road as well.
In the same building?
The same building.
Okay. In Production Act 2 of 1991.
That's correct, Your Worship.
And therefore, in the same vein, after it was established, the parent company now, the subsidiaries were then thereafter established. There cannot be an establishment of a parent company without the subsidiaries. The parent company first and then the subsidiaries. You agree?
Yeah, the subsidiaries were established later.
Okay. Now, Mr. Mulunga, when you... So the analogy you are trying to put, I'll put it to you, is you trying to put the analogy that, well, the hand is not part of the body. Is that what you are saying with regard to the relationship between NAMCOR Trading and Distribution and NAMCOR, the parent company?
No, it's not what I'm saying. All I'm saying is that according to the law and according to the registration of the company.
just slow down.
Making, if I may continue, Your Worship, making NAMCOR Trading and Distribution a private company, not a public company.
Bulk storage facilities, do you see that, sir?
As I said, Your Worship.
Comprising those assets and any and all equipment used by Enercon in conjunction with the operation of said assets set forth in Exhibit B attached here too. Conflicting versions in this court. In fact, yesterday in your evidence in chief, or rather in cross-examination by Mr. Namanje, you said you were buying bulk storage facilities from Enercon. Are we in agreement?
We are in agreement, Your Worship.
Yes.
Just hold on.
Your Worship,
Yeah.
the proposition being put to the witness must be fair and in context. You would recall, Your Worship, that Mr. Namanje asked this witness specifically to classify what these bulk storage facilities are that is referring to. The confinement to simply stating to this witness bulk storage facilities, Your Worship, is under those circumstances unfair, because it was elaborated what those assets are, Your Worship.
He has answered and the objection is overruled. Yes. We can proceed.
Thank you, Your Worship. Now, but then the agreement that you entered into, by you, I mean you as the managing director of NAMCOR, which is the National Petroleum Corporation, the agreement that you entered into with Enercon was for the bulk storage facilities.
I did not enter into an agreement with Enercon as managing director of the National Petroleum Corporation of Namibia. I entered into an agreement with Enercon as the managing director of NAMCOR Trading and Distribution.
Not to do anything about that. Please,
Yes,
the court, Your Worship. not to do anything about that. Please, the court, Your Worship.
The question was clear, and the answer was also very clear, that he did not enter as MD of NAMCOR, but in his capacity as MD of NAMCOR Trading.
Please, the court, Your Worship.
Yes.
It was claimed that MTC was not a subsidiary of Namibia Post and Telecommunications Holding. In fact, in that judgment, the court says it is indeed true that MTC is a subsidiary of Telecom, and as such it receives funding from government, and therefore they cannot be a separate entity. MTC cannot claim that, well, we are not part of this entity. So I just want to bring that to the attention of the court. In fact, when we adjourn, I would add documentation necessary to ensure transfer of ownership of the assets to NAMCOR, NAMCOR Trading. Do you see that?
Yes, I see that.
Now, before NAMCOR Trading, as you are saying, or as the document says, paid the 53,212,000. Did NAMCOR trade they?
Yes, they did.
They?
Yes, they did.
Okay. Are you in a position to show us? Because we have not seen that. Where is that?
It's basically the asset register.
Okay. You agree with me that the word ownership documentation is not used in the same way as asset register. They are quite different aspects.
Objection, Your Worship. I think the ownership of the asset today to NAMCOR. Please, the court, Your Worship.
Advocate Mulunga.
I disagree with that proposition, because the word asset register and ownership documents are not the same. So he's misleading the court with that objection. An asset register and ownership document, something that is in your register, would not necessarily...
It's semantics, and at the end of the day, it will go to arguments to see whether the word "or" indicates whether NAMCOR Trading or Enercon had the option to submit one of those listed documents, or if the word "and" is used to say all those listed documents necessarily need to be submitted. But the issue of those assets purchased by NAMCOR Trading belong to Enercon was clarified when my clients submitted their evidence. So I think my colleague should also have regard to that evidence when posting unfair questions to this witness in the box.
Any response? Ownership was provided. So that answer has been answered. Have been put and answered.
Yes.
Yes. Whether it's the asset register or something else,
as the
do
court
you understand? But his position is that it was provided, and according to his evidence, the asset register was the proof of ownership. That is for the record. But what page?
That would be, if I may assist, page 77. That would be, if I may assist, page 77
yes.
of bundle D1.
Yes.
77 and 76.
All right. Let's proceed to page 76. Of Enercon, do you see? In fact, it's on page 77. It states that as that.
I don't agree with your first point, that they are the ones that did the... What did you say?
Let me put it this way, Mr. Mulunga.
Can you maybe just let him finish?
Okay.
Yes.
Yeah, I mean, I agree that they are the ones that wrote this letter to me and actually gave me the proof that this is the assets that belong to Enercon. That I can confirm. I don't know whether they did any other studies.
Okay.
They wrote this letter.
All right. Ducatus Financial Consultants, what entity are they? What do they do specifically?
Of Enercon. I don't know why my colleague is putting that question to this of Enercon. I don't know why my colleague is putting that question to this witness when he failed to put it to the appropriate persons who would have been in the best position to give that evidence.
Yes, yes.
Your Worship, if I may, in addition to that, my objection is a simple one. The witness says, I do not know these ducatus. Then my colleague follows up with a question of putting a statement to the witness that he must either confirm or dispute about something that he does not know. That is unfair.
The internal auditors, Enercon Namibia, were to provide Enercon Namibia were to provide proof of ownership of the facilities, and that is what was done.
Okay, so when you received this document on page 76, you received it under what circumstances, knowing what did it mean to you? It came from what entity?
No, from the internal auditors of Enercon.
All right. Now, let's go back to the money, 53,204,000.
Objection, Your Worship. That question was asked many times and answered many times. And the witness referred to the said asset register as provided by the auditors of Enercon. Let's not be repetitive, Your Worship. If he doesn't have a question to ask, he can simply raise his case.
Any response?
Well, it's a different question, Your Worship. No. So because it says before the payment of the purchase price. That's what the question is premised on. And here it says on page 53, that was at the time the agreement was being entered into. And at 54 it says the payment of the purchase price.
From the applicant, the first applicant, in as much as you put that question, it appears he will not change.
Yes.
Do you have any other different answer?
I have no different answer to that question.
All right. I'll move to page 63, still of that same bundle, which is an offer to acquire Enercon Namibia. To that letter dated 8 July 2022. On the bottom there it says, yours faithfully, Immanuel Mulunga, Managing Director. So it was you that made the offer. You agree?
Yes, I agree.
Okay. And what you offered to acquire were the assets, not the title rights, because the keyword being the assets. The assets. Are we clear?
Yes, we are clear.
Okay. So when did the issue of rights, interest, and title then come in, if what you offered to purchase were the assets?
Your Worship, I have to object. We are right, title and interest in and to the assets come from. Your Worship, we must not forget that in addition to being officers of the court, there are certain things that govern how we do our work. It's not for this court to go into an agreement that is entered into freely between parties that don't involve any of us and go and decide and impose an interpretation to those terms that are enclosed there and agreed to expressly. So we have to move from that premise and
authored the document. So again, I have to say the objection is meritless, is baseless, because I have moved past the agreement.
The question is very, very specific on the offer itself.
Yes.
Counsel is using the words written on the offer itself. So this question...
This offer is a fuel supply agreement between NAMCOR Trading and Distribution and Enercon Namibia Pty Limited.
Well, when you entered into the agreement with asset purchase agreement with, so why then are you why then are you saying the document or the something that best the asset purchase agreement is the fuel supply agreement when you were already in agreement to supply fuel to them?
Okay, I'll answer
Your
that.
Worship, may the witness be allowed to answer and also be taken to that fuel supply agreement so that we have a complete picture, Your Worship. That is at page 185 of the bundle which we submitted yesterday. Because we can't be asking a question from the air without referring the witness to the document we are talking.
On the document before court, I would understand, but you want him to go to that document?
No, to assist the witness, Your Worship, because the witness referred to that same document.
Yes, but if the witness does not understand, he will say, I don't understand the question. The witness is saying, no. According to him, what based the asset purchase agreement was the fuel supply agreement. Yes.
Yeah,
So,
Your Worship, I would like to go there maybe just to answer the question
Please continue.
completely. The preamble of that document on page 186 of the bundle,
at what page?
186 of the bundle that was issued by my legal representative. Whereas the buyer wishes to purchase products exclusively from seller for its customer, the Ministry of Defense and Veterans Affairs, Government of the Republic of Namibia. Because there is a difference, Your Worship, between buying a while.
Yes, I'm not sure, counsel, assist if I'm wrong. I am not sure because your answer was, why does he say the fuel supply agreement birth the offer or the asset purchase agreement?
Yes, that was my question.
Yes.
Yeah, and the answer is clause 4.5 of that fuel supply agreement. 4.51.
Yes.
And if I may read,
you can proceed.
yes. That clause says the seller and the buyer, this is now the fuel supply agreement between the two parties. The seller and buyer to enter into negotiations with respect to the purchase of all assets, pumps, canopy and tanks and related equipment belonging to the buyer, herein referred to as equipment, at a market-related value to be established by the parties' joint technical team. The parties further agree to negotiate within a reasonable time an amount that could be set off against the debt owed by the buyer, if any, at the time of negotiations with regards to the acquisition of the equipment. So it is not the offer
Your Worship, the witness made it clear that
proceedings, that the state should provide the bail applicants with disclosure of documents
of 2013. It's a High Court Main Division Judgment 202. It was delivered on 18 July 2013, wherein the issue of disclosure during bail proceedings were dealt with, and the High Court clearly stated that the accused persons must be informed fully of the charges preferred against them, and they must be provided with any and all documentation that will be used, at least as far as bail proceedings are concerned, in opposition of them being granted or being released on bail by the state. So on those bases, Your Worship, if my colleague accepts and respects authorities of superior courts, the defense...
It talks about an accused person to be given an opportunity to prepare their defense before they can approach the court. This is a bail application. The state is objecting to bail. They have set out the grounds for objection. And in support of those objections, they must put forward evidence, including documentary evidence. Applicants, as a decision must be made. Please go to Your Worship.
Your Worship, if I may, I know that the court invited us to make submissions in respect of the issue of disclosure, but I submit with respect, Your Worship, that the issue comes down to just one distinction, the distinction between disclosure of the police docket, which is a separate issue and governed by different principles in our law, and the second one is disclosure for purposes of bail proceedings. So, Your Worship, when you evaluate our submissions, that is the prism through which you must look at these submissions that are being made by all counsel. In addition to that, and that is actually more important, this issue was already overtaken by events. Where we are now is a document was given to one counsel. So there's no debate about whether they should discover or not, and that is what I understood from my colleague, that he understands the principle pertaining to disclosure in bail proceedings. That is why on the first day he requested time, he refused that document, and for some reason that refusal is imputed to all of us. And when it is being raised by Mr. Casper, he is effectively being told to keep quiet because it's not his client. While we know very well that these charges are framed and are related to, the way they frame them is to say people were acting in concert, if I must put it simply. So it might appear...
We do not take issue with that, and those documents are submitted to court. But when we want to disclose to them, they refuse the document, say, I'm not going to receive that document. That leaves us in a predicament, Your Worship.
Yes.
Of one of the bail applicants were handed up by agreement. And the expectation was that there is no, or at least the understanding was that there was no objection from the state insofar as the contents of those personal circumstances were concerned. Belatedly, the state raised the issue concerning ownership about title. That he should stand up and make a submission that we have been refusing the acceptance of documents, Your Worship. The acceptance of documents, Your Worship. You will no doubt recall, Your Worship, that we have been complaining about the shambolic state in which we keep receiving documents in these proceedings. But we have no less been accepting them, Your Worship. So my colleague for the state should just do the honorable thing, Your Worship,